24 at 9:28 a.m.
Court will note the appearance of Mr. Vanderhorst on behalf of plaintiff, Mr. Umloff on behalf of defendant. This matter is before the court on the defendant's motion for modification of custody, parenting time, support, and other relief. Mr. Umloff.
Your Honor, the parties have two children, ages 16 and 14. Their current orders give them joint legal and joint physical custody and equal parenting time of those children. However, circumstances have changed significantly. In August of last year, the plaintiff moved from his house in Battle Creek to a two-bedroom apartment in Kalamazoo, Michigan. He did not tell Ms. Smith when or where he planned to move, and she, in fact, did not learn that he moved to Kalamazoo until months later. He still refuses to provide Ms. Smith with his new address, despite a request that he do so. He hasn't updated his address with Calhoun County, friend of the court. It appears he is working for his apartment complex, but I do not know which apartment complex that is in Kalamazoo, and there are many. More importantly, the plaintiff has not seen or had contact with the remaining minor children since he moved to Kalamazoo. He's missed their holidays. He didn't even wish them a Merry Christmas. He hasn't attended their sporting events. He missed the 16-year-old getting her driver's license. He has not even reached out to my client to ask about the children's well-being. Just a little bit before moving to Kalamazoo, he did send the children a text message stating that he had sacrificed his financial stability and freedom for them, which we attached as an exhibit. Because he now lives approximately 40 minutes away, and the minor children are in high school and involved in the community, they have several extracurricular activities in this area, it is simply not feasible to continue a 50-50 parenting time schedule. The children have been deeply hurt by the plaintiff's decision to cut them out of his life, and for that reason do not want to go back and live with him full time, and certainly do not want to live with him half the time. Even though he hasn't seen the children in about 6 months, my client, due to the current child support order, has been paying child support to him, even though he hasn't had the children with him, and he hasn't provided any financial support for the children. For this reason, what we are asking is that the court grant my client legal and physical custody of the children and award the plaintiff parenting time at her discretion. We also ask that the child support order be recalculated according to the formula. If the court is inclined to order an evidentiary hearing on this matter, we would request that my client's child support obligation be suspended as we wait for that evidentiary hearing. We would further ask that my client be permitted to claim the minor children as dependents for tax-related purposes, as they have been living with her full time. And again, if the court is inclined to order an evidentiary hearing, I would request that we be permitted discovery to further explore where Mr. Pemberton is living and where he is working, and to get a sense of his income in advance of that hearing. Thank you.
Okay, thank you. Mr. Vanderhorst.
Yeah, thank you, Your Honor. Does the court have my answer?
Yes, yeah, we received that.
Thank you, Your Honor. When we filed that answer, my assistant noticed that my answer was the 201st entry in this case. I'm new to this case. The court's well aware of the long history in this case. The divorce was in 2013. Here we are 11 years later. The parties have 3 children. Mackenzie's 18, Michaela's 16, and Madeline's 14. So the courts has jurisdiction over the 2 younger daughters. There's a lot of false statements in this, Your Honor. My client has given his address. My client has given his address to the friend of the court. My client has not seen the girls. The girls are teenagers now, and it is not because of his doings. We believe that there's just an environment at the home of the mother that does not promote it, that does not respect the court order. And so the defendant here has been really in violation of the court order for the last 6 months. My client did sell his place he had in Battle Creek area, did move to Kalamazoo, but that's the most of his work is in the Kalamazoo area. He has a nice 2-bedroom apartment that has a bedroom for the girls to stay. He did purchase a car for them. I believe Michaela can drive now. She's 16. And he loves his daughters very much and would like to continue the parenting time arrangement. There's an established custodial environment with both parents, Your Honor. The other important factor in this case is there was a court order before regarding counseling, and I believe counseling now would be very, very fruitful. And I did reach out to Margaret Hunter, who's a very skilled counselor. I've used her before in other cases that could deal with the family issues we have here with the teenage daughters and the parents. And I have made that known to opposing counsel that Margaret Hunter, spoken to her, would be willing to take this case on and get involved with this family to kind of bring healing back to this family. I know the counselor that was court ordered before has retired, so she is no longer practicing, but I believe this case would be just tailor-made for Margaret Hunter. As far as the tax exemptions, there was a court order to that effect back in May of 2015 that awarded the tax exemptions. And my research was, I'll give you, it's been a few years on tax exemptions. They can be either be property where they're non-modifiable if they're awarded, or they could be awarded in child support. But in this case, clearly they were ordered back in 2015, where the parties basically share the children because they've been sharing the children as far as parenting time. So going forward, Your Honor, I would like the order to be enforced. And the issue of child support, my client's willing to say no child support. He would terminate the support as far as I think she's paying $100 a month, Your Honor, or something to that effect. Would waive that for now. But he does make substantially less than the defendant. I believe that I haven't subpoenaed incomes or anything, but I believe the defendant is making close to $100,000, if not more. My client he's self-employed, $50,000 or so. So he makes substantially less anyway than the defendant. But I would ask that the court order be followed, Your Honor, that counseling be ordered in this case, once again, with Margie Hunter, who's a very good counselor, that the defendant, not badmouth the plaintiff at home or do anything to that effect, promote the girls to see their father, and to go forward in this case in a positive way. We only have a few more years left before we're across the finish line, and I think counseling actually would be very helpful to these folks.
Yeah, thank you.
Your Honor.
Mr. Vanderhorst, when you say that your client's willing to terminate child support, do you mean actually we terminate that effective at this time, or are you talking about suspending it?
Oh, well, yeah, I probably use the wrong term. I would say we would suspend support now. I mean, to move this along as far as what the defendant is paying him at this point in time. I think that would be an act of graciousness as well.
Okay, thank you.
Your Honor,
Mr. Umlauf, what's your response on the counseling issue?
Firstly, I have not received opposing counsel's answer to my motion, but he and I have had extensive discussions on what he's presented today is consistent with what he and I have talked about. As it relates to counseling with Margie Hunter, we would not oppose it. I did have an opportunity to speak with Margie Hunter, and she did confirm that while she had spoken with opposing counsel on this matter, she has never treated Mr. Pemberton or had any involvement with this family previous. And so I think she would be an appropriate counselor.
Okay.
However,
go ahead.
I would still note for the record that given the distance and the length of time, our position is still that this is a significant enough change of circumstances to warrant an evidentiary hearing to revisit legal and physical custody and certainly parenting time.
What we'll do is the court does believe that based upon the pleadings and basically the argument today, that the defendant has met the threshold of the BARCA 4 proper cause, change in circumstances sufficient for an evidentiary hearing. The court will, in the interim, based upon the stipulation put on the record, the court will suspend the child support obligation effective today's date through the pendency of this and until we have a resolution of this matter. The court will further order counseling with Margaret Hunter. The parties can utilize that for purposes of, if you want to say co-parenting, or also for purposes of reintegration counseling, whatever you want to call that, but we will set it up in that manner. I'm going to give you some period of time, maybe 90 days of counseling before we would schedule the matter in, but we will contact your offices and find out a time when you're available after the 90 days. And hopefully Ms. Hunter can make some inroads and then make a recommendation to us at the end of the 90 days as to where we're going to proceed with counseling, or how the counseling is going, et cetera. Mr. Umlauf, I'll ask that you would prepare the order, and you can submit under 7 days.
Well, one question, Your Honor, and that is, what about my request for discovery as we await the evidentiary hearing?
Well, you've got 90 days to while the counseling's going on. I guess you could affect discovery during that 90-day period.
Thank you, Your Honor.
You can put that in the order as well, Mr. Umlauf.
Thank you, Your Honor.
Okay. Thank you. You're free to go. Have a good day.
Thank you, Your Honor.
Thank you.
Thanks, Jared.
Thank you.
Court will note the appearance of Mr. Cobb on behalf of the defendant. This matter is before the court on the plaintiff's objection to the proposed order. Mr. Brown.
Yes, sir.
It's your objection. You can proceed on your objection.
Okay, I feel that, Your Honor, I feel that the attorney fees are not warranted. I did not do anything to generate their attorney fees. You did not fine me for the other reasons. I was misled by CPS, but I was only acting as a father trying to protect my son. In the last hearing, you were incorrect in your information as far as there not being any type of order before Judge Snyder's order or Referee Snyder's order of Mac Turner to not be at that address. There was a bond stipulation. He was not to be at that address. He is a threat to my child, so he should not have been at that address. I provided the court with proof that Crystal admitted that he was there at that address around my son. And that, again, as I said, when I returned Elijah to Crystal, she told me she wanted to keep him in Lakeview and put him back in Lakeview. Lakeview completely does not make sense for me. Crystal can bring Elijah to the bus stop over where I live for Harper Creek, and she can still get to work on time. I'm having to rearrange my entire life and drive all the way across town to make her happy with Lakeview. So when she told me she wanted to do that, I said, okay, go ahead and put him back in Lakeview. As long as we have the agreement that you're going to get him on the bus in the morning, I'll drop him off to you. You're going to get him on the bus in the morning. So before we even had that hearing that Mr. Cobb set up, which I think is just a scheme for more attorney fees, I think he's a scam artist. He was already back in Lakeview. So there was no need for any type of hearing. He created that hearing. He generated those attorney fees, not me. But the other thing,
Mr. Brown, let me cut you off here because we're getting a lot of other things. Your objection to the proposed order, the basis for your objection would be that the order does not reflect the court's ruling. If the order reflects the court's ruling, the court will enter that order. If you object to the court's ruling, you have a right to appeal to the Court of Appeals to seek a modification or, again, a cancellation or vacating of the court's order. But that's not what we're here today. Today is simply, does the order properly reflect the court's ruling?
I don't think the order does, because in the first hearing, Attorney Cobb only asked for $500 attorney fees. But then after being angry with me out of spite and pettiness, he jumped to $1,500. Please explain how that jump happened.
Okay, again, that goes to the issue that you need to take with the Court of Appeals, the court does recall the court had ordered $1,500. So with that, that's not a basis for an objection. That's the basis for an appeal. So you have a right to an appeal. You can take the appeal, but filing an objection is not the proper procedure to basically object to the court's ruling.
I should have never been charged. So
Okay.
this court in complete dereliction of duty as far as keeping my son safe. That attorney is trying to commit larceny by conversion. I'll go file they're crying about attorney fees. That's fine. I'll go home, get on my laptop. I'll file my appeal and we'll be back in court for another custody hearing too.
Okay. Well, you have a right to do that, sir. At this
No.
point, the court has not been presented with any basis to object to the proposed order in this matter.
He
So
asked
the
for
court will enter that order. Mr. Brown, you can proceed with the Court of Appeals if you have an objection. Anything else, Mr. Cobb?
No, Your Honor. Thank you very
Okay.
much.
Thank you.
What about his
excused? Have a good day.
perjury?
This hearing is over, Mr. Brown.
Okay, well,
Go to the Court of Appeals.
I'll be suing you for dereliction.
Go to the Court of Appeals, sir.
Thank you, Your Honor.
Thank you.
We're at 9:47 a.m.
Court will note the appearance of Ms. Reed on behalf of plaintiff, Mr. Ansley appearing in pro per. Matters before the court on the plaintiff's motion to correct the UCSO set aside order of makeup parenting time in this matter. And Ms. Reed, go ahead.
That's correct, Your Honor. We have two issues. One, on the UCSO that was submitted and entered a couple of weeks ago, there was a clerical error that swapped the payer and the payee. So we're requesting that the defendant be the payor pursuant to the guidelines as ordered on the beginning of January. And our second issue is the defendant had filed a parenting time complaint and we submitted a timely response. But the court clerk appears to have entered that response as a response to a motion in the court clerk's file instead of sending it to front of the court as a response to the 21-day notice under the parenting time complaint. So an order was entered for makeup parenting time, even though a response was submitted. So we're requesting that order for makeup parenting time be set aside because after that order was entered, ordering makeup parenting time, the other order was entered saying that the defendant doesn't have parenting time until he participates in reunification counseling because he hasn't had any parenting time in about 2 years. So we're requesting the attached child support order with the correct payor and payee be entered and an order setting aside the makeup parenting time order.
Okay, thank you. Mr. Ainsley, what's your response?
My response is not my fault that I missed out on almost 2 years of parenting time. That's the mother's fault. So I do believe I should get my makeup parenting time. Also,
Okay, Mr. Ainsley, just to clarify, what Ms. Reed is arguing is not anything that goes to the substance of the makeup, but she's arguing that they had filed a response, but the clerk incorrectly docketed that so that it did not appear that they had filed a response. And therefore, she wants to set that aside. It'll go back to the original proceeding, and we'd have to have that proceeding all over.
I don't know about that. I don't believe that there was a real excuse for the denial of the parenting time. So I believe that the makeup time, or I believe that they didn't have a good enough excuse to deny the makeup time.
What she's saying is we do have a defense, but the defense was not properly docketed by the clerk, and therefore we couldn't raise our defense. So it'd be no different than if you filed a response and it didn't get docketed, and so it doesn't appear that you responded at all. They're just saying, we just want the opportunity to be able to respond to the original petition.
Okay, I really don't know what to say about that, but I understand.
Okay. Well, what the court's going to do in this matter, it does appear that the motion is well founded. The court will vacate the order for makeup parenting time and reset the matter before the referee. That gives the plaintiff the opportunity to present any argument that she may have in this matter. Mr. Ansley, that doesn't mean that the same result won't happen. I'm just saying that that gives them the opportunity to, again, dispute the petition. The court will grant as well an order correcting the payer and making that making the correct payer in this particular matter. And so, Ms. Reed, you can prepare. I don't know if you want to prepare two orders to that extent or just having one order. That's up to you.
We did submit a corrected UCSO with our motion.
Okay, we'll pull that out. It's probably attached and we don't have that out. So we will.
I have two UCSOs, Jennifer. One was submitted on the signed by you on February 26th. And then I also have a corrected UCSO that's signed by you on February 21st.
It would be the later one having Mr. Ainsley as the payor.
Okay, we will make that correction then. Ms. Reed, you can prepare an order as well vacating the other one and revert. Well, you can vacate that order and then we will do an order referral, refer it back to the referee.
We will do that.
Okay, thank you. You're free to go. Have a good day.
Thank you.
At 10:14 a.m.
Right.
Court will note the appearance of Ms. Cochran on behalf of the plaintiff, Ms. Capture on behalf of defendant. This matter is before the court on the plaintiff's motion to enforce an alcohol provision in the judgment and for order of show cause in this particular matter. Ms. Cochran.
Thank you. As detailed in the motion, the judgment of divorce contains very specific alcohol-related provisions. The alcoholism that led to the breakdown of the marriage was noted during the pro-con hearing, and also with regards to section 2.5C of the judgment, it is incredibly clear that that not only was there a prohibition on drinking alcohol to the point of intoxication or drunkenness during or before or in the presence of the minor children, even if it wasn't during parenting time, that there was two specific consequences. One of them is just the general, that upon admission of reasonable proof that the offending party's parenting time shall be reduced to alternate weekends and a midweek non-overnight pending further hearing. So section C1 specifically anticipates entry of a temporary order pending further evidentiary hearing. With regards to subsection 2, was specific to address issue of driving under the influence with the children. Now, I do want to emphasize that section 1 is reasonable proof. We are not here asking, or I am aware that the other side, Mr. Kinney, will probably be arguing that we need some sort of absolute beyond the reasonable doubt kind of criminal threshold. We specifically put it down upon reasonable proof of same. Given the seriousness and the long history of alcoholism in this matter. With regards to section 2, again, reasonable proof of same. Now, as noted within the motion itself, there are several instances where the children are sending photos and even now a video to mom of dad of the drinking and the bottle. Well, I don't want to just describe the videos, but the video and specifically does show that I think that it looks like the kid is in the back seat, dad swerving all around. So to the extent we have pictures of dad with alcohol and, you know, bags and bags of empty beer cans, and now this video, and on top of that, we have multiple reports to the school counselor, and multiple reports to their children's therapist. They have a therapist that they're seeing, who I got a call from her this morning and an email about it as well, who's perfectly willing to participate in this as well. We have children who are,
Ms. Cochran, I'll ask about that. How could the counselor participate in a hearing to determine whether he was intoxicated?
so to the extent that the children are making statements for the purpose of medical or mental or emotional health treatment, then that would fit under a hearsay exception so that the counselor would be able to address some of those things.
Well, the
Also-
counselor couldn't testify as to any of the specifics, just that was the report to them.
Correct. And so it
Okay.
would go under, I guess, to the weight of the testimony, not necessarily, and as far as the effects of on whatever the children are observing or experiencing on the children. The therapist, of course, would have to stay in her lane as far as testifying, as far as the emotional impact or emotional and mental health things that the children are experiencing. Same thing with regards to the school counselor. Of course, they're not in the home, and I mean, we're all aware of that, but they can essentially see the ripple, because we are here because there's this stone being thrown into the pond repeatedly. And so we have people seeing the ripple. Obviously, it's circumstantial evidence. The video is not that circumstantial, quite frankly.
Okay.
It's
Fine.
direct.
That's the only question I had, is when you brought that up, I thought, well, how was the counselor gonna
Right.
get any information?
And we have these children who are, I think it's an extreme step to be taking photos of your father trying to catch them, and you can't see because they're not in evidence, but it's very obvious that they're kind of like they're not like direct, it's kind of like hidden pictures. I don't know how to explain it without showing it, kind of like through a reflection, and just trying to I mean, in the
Okay.
video, when they're in the dark in the back of the car while their father is swerving around, and I just don't know how much more evidence we can have. Obviously, we can bring the children in to testify. The whole thing is that we have such a very specific provision in the judgment. We shouldn't need to have the children come in to testify. Right now, we're here because we want to enforce the plain language of the judgment, to have a temporary order consistent with the language of the judgment that they agreed to, pending the further hearing as the judgment anticipates. I understand that they are going to argue that maybe there's this fine line of what is intoxicated. We are not, Sophocles here trying to have some philosophical debate of, is it point this or point that? We're talking about if it's visible intoxication to the eye of the beholder. And we're talking about children. If children are observing their father and believe that their father is intoxicated to the point that they're reporting it and having this ripple circumstantial evidence to all these adults, and then, something has to be done, quite frankly. Now, last week, I believe it was last week, upon obtaining the motion and being ordered to come to court, Mr. Kinney drugged these children to Christ Enderley to have them interviewed, them interviewed by counsel and I think that counsel wrote this morning, I closed down knowing that they would have to testify or something. So we're at this position now of it doesn't matter if they're 14 going on 15 or 15 going on 16, they're still minors. And there's forensic interview protocols going on, which are now being tampered with. When you have children who are reporting and going to such great lengths because they're afraid of their father who is drunk or intoxicated, and then when finally there's a report and something is being done, and then to be drugged by the father to his attorney, who in my office, children aren't allowed. I send them home. But there, where they are presumably grilled into saying, I don't know what they were saying, quite
Well,
frankly.
let's find out from Ms. Capture. Ms. Capture, are you disputing the allegations in the petition?
Yes, Your Honor, we are disputing them in their entirety. The statements made are completely rely on hearsay and are in large part completely false. There's been a breakdown, it's clear, between the communication of the minor children and dad. And so that's why we suggested within our answer that family counseling occur. The eldest child, who's an adult now, lives full time with dad. He witnesses parenting time every single time the boys are over with dad. He will easily testify, I've communicated with him, as to the fact that mom has a grudge against dad, will continually say that dad's an alcoholic, has kind of built this into the brains of the boys who now have any kind of fear for alcohol, and are quick to say anything that mom has said. Obviously, Your Honor, it seems like there may be some kind of parental alienation here. The boys were not drug into this office. They did communicate with me willingly. I had a witness in the room. I specifically told them, you are not being forced to talk to me. You don't have to talk to me. But the boys are old enough and have an interest in this matter. And if the allegations that were contained in this were true, the boys would have said so. The fact of the matter is dad is willing to prove a negative and participate with SoberLink to dispel any of these fears. These boys don't need to go through any more drama. Obviously, there's some therapy that's needed between dad and mom, between dad and kids. And the boys didn't feel comfortable talking directly to their dad about this particular issue. Whether that's the influence of mom or influence of others, we don't know. And I'm not a licensed counselor to determine that. Your Honor, it's simple that they say that they have these videos and these images. Again, we were not produced with these images or videos until Friday afternoon. I took a look at the video. No one's in the video. You can't see it. It's late at night. What you can see is that the person driving is moving into the center lane, which is reasonable for Michigan, rural Michigan. I don't know if you have had this experience, but I certainly have, with a deer coming out randomly. Many drivers will drive cautiously during late night when there's not a lot of moonlight and they can't see very well. Your Honor, there's also some photos that show alcohol bottles. None of them have a picture of Mr. Kinney holding an alcohol bottle. None of them have a video of him clearly intoxicated. Again, these are 14, 15-year-old boys. They're not in a state where they can comprehend what intoxication is. An adult can directly contradict the fact who has witness time all the time with dad and the boys that says, no, my dad's never drunk in front of the boys. My dad's never drunk in general. He has a beer here and there, but there is this fear, unfortunately, this fear that these boys have of alcohol. And so, Your Honor, the statute or the clear language of the order is clearly not met. It states that upon reasonable proof of alcohol intoxication, that proof has not come about. Any kind of proof may have been hearsay, but that can be directly contradicted by an adult who witnessed parenting time. The CPS worker has already closed this case, has no concerns about the safety of the boys. Again, Your Honor, this comes down to a breakdown in the parental relationship with the boys. And despite all of this, the boys did, without me even prompting them, say, we don't want our dad in trouble. We just don't like talking to him about stuff. So again, Your Honor, this is not one of those cases that needs to go through an evidentiary hearing when we need to put the children of these two parties on the witness stand to verify the pleadings. Instead, what needs to happen is SoberLink needs to to be instituted, and there needs to be some kind of family counseling. Thank
Okay.
you.
Thank
Nothing
you.
further.
Ms. Cochran, obviously, based upon the allegations in this matter, the court does believe would be appropriate to have a evidentiary hearing, being that the allegations are disputed. And the judgment does state that again, the defendant is prohibited from consuming alcohol to the point of intoxication or drunkenness during parenting time. So again, the court's going to have to make a determination on that. What do you feel in the interim as it relates to sober link or counseling?
So, with regards to counseling, and I did want to note that on one hand, if they are arguing that that is all completely false, but then
Okay, I don't want to get into that, Ms. Cochran.
Okay.
I'm asking you
right. So with
about
regards
in the
to
interim
sober link,
to institute sober link
yes,
and or counseling.
yes. So counseling, I do think that alcohol counseling for Mr. Kinney is absolutely necessary. I think
And ask about alcohol counseling. I mean, counseling between the children and their dad or their mom, based upon what the counselor would say.
I think that I would like to hear from the therapist as far as whether or not that's appropriate.
Okay.
Yes, as far as, because I do know from other matters that generally sometimes there needs to be some individual work before everybody is brought in all together so that it doesn't turn into a confrontation.
Who is the counselor at the current time with the children?
It is Lacey Merchant, LPC, of Comforts of Home Counseling and Care Management.
Ms. Capture, do you have any problem with Ms. Merchant continuing the counseling?
Your Honor, I think the counseling is supposed to, the issue I have is that these boys have a safe place with this counselor, and this is their time to speak just by themselves. I would think it would be more appropriate for a family counselor to be separate from this. Obviously, Lacey could communicate with that family counselor, but I would suggest Meredessa Katz, who is more experienced in dealing with co-parenting counseling and reunifying families when there's these types of tensions.
Okay. Ms. Cochran, do you have any problem with Ms. Katz serving as I don't want to say reunification or as a neutral counselor in this particular matter, or?
I'm not familiar with Ms. Katz. I'm not in
Okay.
county as much, so I'm not familiar with Ms. Katz.
We have used, Ms. Katz has testified in a substantial number of hearings before this court. She's clearly capable of doing it if she's willing to do that. Why don't we do this as the court will order that Ms. Katz would be involved for purposes of, again, the counseling with the defendant, the children, and or the plaintiff based upon what she feels is appropriate to engage in counseling. The court would order that based upon the agreement of the parties and that the defendant would utilize the sober link during the times that the children are in his care. And Ms. Capture, I'll let you make arrangements for that. Obviously, the court's not concerned in the times that, again, the children are not with him. So that, I mean, because that's not really an issue in this particular matter. So.
Your Honor, I would ask with regards to SoberLink, because within the program, when you sign up, there's different options of signing up, whereas definitely randomized, which would, of course, test during times when the children aren't with him. You can't.
The court has no problem with doing it randomly at times that the children are with him, but I'm just not going to make it 100% when the kids aren't with him or anything like that.
So, Your Honor, it's my understanding that SoberLink can like it because it takes away the randomness when you set date parameters. And so the other option is setting particular times per day on a set schedule. And so we would ask, because SoberLink is so easy, everybody has their cell phone on them, that he do 3 times daily testing during his parenting time, 11, 4, 9 p.m. Just beginning, middle, end of the day. Because it's my understanding that the SoberLink program that you cannot constrict, and maybe it's been updated. I don't know. But the last time I tried to do that, I was told from SoberLink that, you know, it kind of takes away the randomness when you say it's only during these particular parameters. And then if we wanted to do that from like maybe a technological standpoint, I don't know why,
Okay.
but that is the way to do it, to say, okay, this is the parenting time schedule. And so that's my understanding.
Yeah. Miss Capser, what do you say about during the times they ask the children have some set times?
Your Honor, I think that would be fine. I'm worried that, I mean, I don't know the intimate details of SoberLink and how it charges. How I typically do this is that, you know, he blows once in the morning, blows once in the evening while with kids, and that's usually the terms of how we set this. I mean, if we want to do it once in the morning, once in the afternoon, once in the evening, that's fine. My concern is that this creates additional costs because he has to utilize the program more. I think we have to be money
Why don't we do it
conscious.
this way? Why don't we do it this way is, when the times that he has the kids, that he would do it, let's say at, 10 o'clock in the morning, and, there would be only the Saturdays that it would be in the evening. So let's say 10 and 6.
It's my understanding from SoberLink that there's like a 4 or 5 hour window when it decreases, which is why we had requested 3 times per week.
Yeah, we'll do it too, because I'm saying if we did it 3 times, at least on the Sunday, for instance, the one in the evening, the kids wouldn't be there, so it wouldn't matter at that point.
It's also afterwards.
Then
Okay,
on Friday, he's gonna have them in the evening, but he wouldn't have them during the day. So if we did it at 8, 2, and let's say 6, they would only have 1 time. So I'm just saying, I'm trying to set it up at the time when he would actually have the kids with him.
Your Honor,
so it's a Friday through
defendant
Thursday.
has the children week on, week off.
Oh, okay. I was
So-
thinking
so it's-
standard parenting time. for
No,
some-
he has equal parenting with the children.
Okay, well, in that way, it probably does appear that 3 times would work, so why don't we do it at 10, 2, and 6? Would that work, Ms. Coffrin?
Yes, sir.
Okay. Why don't you include that in the order, and then we will, as well as the counseling with Ms. Katz, and then we will, I'd like to give her a period of time to get some counseling in place, so we won't set an evidentiary hearing for about 90 days. That way she can get some counseling in, and then we'll have the hearing at that time. So we'll contact both your offices and see when you're available.
Okay.
Thank you, Judge.
Your Honor, 10, 2, and 6, I'm sorry, could it be 10, 4, and 9? Because if he tests at 6, then he can just drink all evening.
That's fine. 10, 4, and 9 would work.
Thank you.
Ms. Cochran, I'll let you do the order. You can include those times and the other as well.
And the evidentiary hearing is before this court in approximately 90 days. That's gonna be,
Yeah,
Okay.
we'll contact your office to see when both of you are available.
thank you.
Okay.
Thank you, Judge.
You're free to go. Have a good day.
Yeah.
This matter is before the court on the defendant's motion to set aside the referee recommended order in this matter. Mr. Johnson, as I review your motion, you do not state anything in the motion that any error the referee made so that the court would set aside the order. You have to establish that the referee made a factual or legal error. So what is the factual or legal error that the referee made?
Tamika actually lost her job.
Okay. That's it?
Yes.
Okay. Well, she has a right at that point, she has a right to file a motion to modify support based upon losing a job or anything of that nature. How would that impact you, sir?
Well, I got a different job as well.
Okay. Well, if in fact you obviously changed jobs, et cetera, that would be something that was post the referee decision. You have a right to file a motion to modify the referee order, but not to go back and say, well, now something's happened after the fact, so the order is not correct. You would file a motion to modify, not to set aside the referee order.
Okay.
So, see, because it's subsequent to when the referee ruled. So, what
Okay.
the court will do at this point is the court will deny the motion to set aside, as the court does not find that there's any factual or legal basis to do so, but I would advise both parties, if circumstances have changed since that order, you have a right to seek a modification by filing a motion, setting forth what the factual reason is for the court to, again, change the order. So with that, is there
Okay.
anything else, Mr. Johnson?
No.
Ms. Smith?
Yes, I would like to say that there is like a legal part. I was not aware of any of these hearings or meetings or anything. I was not served any papers. The court had my address on file from the last hearing that I had with another person, but I have not gotten any paperwork or anything for any of this. So
Okay.
this is the first I'm hearing about everything.
Okay, ma'am, on this particular case, as in any case, like you said, they had your address from another case involving the cases, we don't get all the cases that you're involved and cross-check addresses. So the only thing would be is in this particular case, you would need to go to the front of the court, change your address on this particular case. And if you didn't do that, then they would have sent the pleadings to the last known address, which would have been the only address that they had. So not aware of what you did or didn't do in this matter, but again, based upon what you said, the court can only infer that on the other case, you had changed your address, but you had not done it in this case, and therefore service would have been appropriate. You have a right, again, if there's a change in this matter, you have a right to petition for modification based upon the change. So, the court will conclude this matter at 10:41 a.m. You're free to go. Have a good day.
Jackson, Attorney Sachs for petitioner plaintiff.
Okay. Good morning to everyone. The court will note the appearance of Ms. Sachs on behalf of the petitioner. The matter is before the court on the defendant's motion to terminate the personal protective order. Mr. Jackson, when I go through your motion, I note that you reference various things that occurred back in 2022 when apparently a PPO was entered. I guess I'm not as much concerned about what happened in 2022 as I'm more concerned about the current PPO that was entered back in January 23rd, 2024. So if we can confine ourselves to that, I'm not going to rehash what happened 2 years ago because obviously there was no action file with regard to that particular motion. Okay. Okay. Go ahead, Mr. Jackson. What would you like to tell me in this matter?
Well, it's been forever since I've seen my kids. I've been trying to see them.
Okay, let me stop you there, sir. The PPO has nothing to do with your kids. If you're not able to see your kids, you can always file a petition in the underlying action to see your children. And that's not involved in the PPO action at all, other than making arrangements to have, pick up and drop off, et cetera. But we can do that in another way. We can do that through third parties or something of that nature. So again, I don't want to hear about the kids because it's not the issue today. The issue is the PPO.
Okay. Well, yes, sir. Well, on the date, it was a whole lot of stuff that was said that was incorrect. About Burger King. I think it was said that hold on one second. It was said that I stood between the door and her. That never happened. When I was told that I would not be able to make contact with my kids for their birthday or Christmas, I gave them a kiss both on the cheek and I got in the car and I left. So that statement, that verified statement right there was untrue. It wasn't any type of incident on either one of the occurrences when I met them just now. Not in just now, but like in April. Not April, but in February.
Okay.
And I've also tried to make contact with my kids by way of maybe like calling to check on them at their daycare. And I was not called back. So my mom called to check and they said I was on a no contact list, which I feel like that's all this is like alienation. I don't have any history
I would object
of being
at
violent.
this point. We're litigating the divorce again.
Okay.
I don't have any history of violence, or I don't even have a speeding ticket. So the grounds that for a PPO, I think is like it was falsified.
Okay. Okay. Anything else, sir?
No, that's it.
Okay. Ms. Sachs, any evidence, testimony you'd like to present?
I have a brief opening statement, and then I'd like to proceed to call Miss Mendelson if I could.
Okay, go ahead.
I am appearing today on behalf of Miss Mendelson, to respectfully request that this honorable court deny respondent's motion to terminate the instant PPO. As I stated, petitioner attempts throughout his motion to mostly be trying to litigate the divorce, and this is not the proper forum to do so. What is the issue today is that Miss Mendelson has lived for years now with a reasonable apprehension of fear of violence from respondent due to his past behavior. I would additionally add that this instant PPO is only granted for a period of 6 months in consideration for the fact that Miss Mendelson has an increased reasonable apprehension of fear due to retaliation on the part of respondent due to the instant divorce. And so for those reasons, Ms. Mendelson will testify as to why she would ask this petition be denied.
Okay.
And at this time, I would like to call Tanisha Mendelson.
Okay.
And what is your relationship with the respondent?
He is my husband.
And are you two still living together?
No,
When did you two separate?
we separated in October of 2022.
And you filed this petition for the PPO, is that correct?
Yes, I did.
And were all the statements in the petition true to the best of your knowledge?
Yes.
Do they remain true today?
Yeah.
You understand that when you signed the petition, you were affirming that all of these were true?
Yes, I did.
How do you feel about testifying in front of respondent today?
I'm very anxious. He makes me feel intimidated at times. When I tried to speak up about the events that have occurred between both of us, I feel scared.
What do you fear will happen if the court were to terminate this PPO today?
Retaliation for the past year and a half.
And would you fear for your personal safety if this PPO were terminated?
Yes, I would.
Going to your petition itself, you refer to an incident that was dated December 22nd, 2022. Is that the correct date?
Yeah. In the first petition, is that what you're talking about?
In this petition for a PPO.
Oh, yes. Yeah. The date is, the year on the petition is incorrect. It should be 2021. My son was born December 23rd, 2021.
And do you remember what occurred on that day that caused this petition to happen on December 21st, 2021?
The respondent.
Okay, hold on, Ms. Sachs. I don't want to go back into something that's that many years ago. I mean, the petition, the PPO that we have that's at issue in this case was entered on January 23rd, 2024. I'm only concerned about what's happened recent and not dredging up years ago.
Understood, Your Honor. This speaks directly to the type of coercive control that Mr. Jackson continues to.
Yeah, I made it clear. Address your proofs on that, or otherwise I'm going to have you move on.
Let's go to December 9th and December 16th of 2023 then. Ms. Mendelson, when we're referencing the Burger King incident, will you tell the court a little bit about that?
We had met once at Burger King the first time. That seemed to go well. So I decided to meet a second time on December 16th at Burger King with him. But we met at the park initially so the kids could play with him. We were there for about an hour, and when we arrived back to the vehicle, I was sticking my 2-year-old Austin in the car, and by the time I had come back around to the driver's side, he had his foot on my tire and he threatened to take the children for a year. I put that aside for the best interest of the kids. So we went to Burger King after that and we had dinner. And after dinner, because of his demeanor and his behavior, I felt like it was not appropriate to spend Christmas with him. He did not like that. He got in his vehicle and drove quickly to the exit of Burger King, stopped and reversed. And I felt very nervous at that point. So instead of going straight home, I took a left out of the parking lot and started driving towards the police station.
And you said that you were concerned about his demeanor. Can you describe that a little bit more for the court?
He was very upset. And I don't know how, when he is upset, he reacts in a aggressive manner. And I am 4'11", about 90 pounds, and he is over 6 foot, and there is nothing I can do to stop him. So I felt intimidated and threatened based on what I've seen in the past.
And Ms. Mendelson, you said that you met a second time. Will you describe that incident for the court as well? That was the second time. And then the first time? The first time went pretty well over at Burger King. We spoke about things from the past. And once I brought up having to apologize to my eldest daughter for his behavior, he started to get very defensive. And we stopped that interaction and he left the home. And Ms. Mendelson, you keep referencing you were worried based on past behaviors that additional behaviors would occur. What sorts of past behaviors generally are you referring to? Intimidating behaviors such as not letting me speak. Aggressive behavior like balling his fists and yelling.
just yelling in general.
Did you ever fear for your physical safety?
Yes, I did.
When was that?
In the past, on when I filed the first PPO, the events that occurred that night made me realize kind of how he reacts.
Your Honor, I have no further questions at this time.
Okay. Mr. Jackson, do you have any questions of the petitioner?
Yes, sir. During the last her last two statements, I lost service, so I wasn't able to hear what was said. Is there some type of way we can get her to repeat it? Because I don't know if something was said that I could defend myself against or what.
Okay, what part didn't you hear?
I don't know. That's what I was saying.
Well, you
I just
gotta
heard
tell
the
me
last
sometime.
part.
You didn't hear the whole thing. You didn't hear half of it. You didn't hear, what was the
Well,
last thing you
close to
heard?
the end, right close to the end. I know what she said. I heard what she was saying, something about the first PPO, and I thought we couldn't like talk about the first PPO.
She said what she testified to, sir, is that she did have fear for her physical safety at the time of the first PPO. That was it.
Oh, okay.
There was nothing said after that.
Yes, sir. At no time have I ever threatened
Sir, it's
my
not your
wife.
time. It's not your time to
my bad.
testify. It's your time to ask questions.
Oh, it's my time to ask questions?
Yes.
Okay. I don't really have any questions.
Okay.
You know.
Okay, that's fine. You don't have to have any questions. With that, Ms. Sachs, any additional witnesses?
No additional witnesses, Your Honor.
Okay. Sir, do you have any additional witnesses?
No, sir.
Okay, thank you. Ms. Sachs, any closing argument?
Just briefly, Your Honor, Ms. Mendelson has testified that the prior PPO was in fact a useful agent in keeping physical and emotional violence from occurring. Once that PPO was removed, there were two incidents directly that she testified to in which she felt intimidated and anticipated future retaliatory action. And it is for those reasons that for the duration of the divorce, we would ask that this petition be continued and that respondent's motion therefore be denied.
Mr. Jackson, any closing arguments you have?
Yes, sir. On those two incidences, I was passing by the house. On one of them, she tried to flag me down and I didn't stop. On the other one, I just, I kept riding. I think it's hard for you to say you're afraid of somebody if they try to flag you down. Other than that, she knows I'm not violent. I'm not a violent person. If we're talking about stuff in the past, it was a lot of situations that happened in the past that would make me aggravated. But I have never threatened violence to her or my children or anybody else.
Okay. Anything else, sir?
No, Your Honor.
Okay. Well, the court's heard the testimony in this matter. The matter concerns the current PPO entered by Judge Yost Johnson on January 23rd, 2024. I know as I review that, they have a litany of, again, allegations from the prior action, and that was a PPO that was entered back in, I believe, in 2022. And as it relates to the current petition, that's why I wanted to confine it. The petitioner has stated that she has fear for retaliation, fear for personal safety. She said that the parties met back on December 9, 2023 at Burger King. The first meeting, as she said, went well. The second meeting on December 16, 2023, that they first met at the park, that they were there for approximately an hour, that again, there was discussion at the car after she put the kids in. She said the defendant put his foot on her tire. And at that time, after that, they went to Burger King to have dinner. She states that the respondent got in his vehicle after being at Burger King. He drove to the exit. He put his car in the reverse, and she said she was concerned. At that point, she somehow felt intimidated because he put his car in reverse. She doesn't say how she felt intimidated or how that would intimidate her in this particular matter. She says that she feels intimidated as a result of past conduct. When she was questioned and pushed about what conduct, it says just yelling in general. And she stated that she did have fear for her safety, but at the time of the first PPL. In this particular matter, the court has to decide and make a determination whether it's appropriate to have a personal protective order pursuant to Michigan Compile Law 600.2950, and it's a subject to the various subsections. The court may enjoin or restrain certain conduct if the court determines that there is reasonable cause to believe that an individual has committed or may commit any of the acts listed in MCL 600.2950 parens 1 A through K. In this particular matter, again, first was entering upon the premises. There's been no allegations of that. Second, assaulting, attacking, beating, molesting, or wounding an individual. No testimony about any of that occur. Next, threatening to kill or physically injure an individual. There's been no threatened action to kill or physically injure the petitioner. In this particular matter, she's not testified to any of the other subsections in that matter. And the last one is sub K, other act or conduct that imposes or interferes with a person's liberty or causes reasonable apprehension of violence. Based upon her testimony today, the court cannot see any conduct that imposes or interferes with her personal liberty or causes reasonable apprehension of violence. The only incident was the incident on December 16, 2022, in which he put his car in reverse, came back in the parking lot, and that's it. There's no testimony about any incident or confrontation occurring after that. Only in her mind, some apprehension. The court has to determine whether that apprehension is reasonable, and that, again, would that apprehension be reasonable to an ordinary individual? The court does not believe that it would in this particular matter, and she has not set forth any basis for doing that in her testimony. As a result, the court does believe that termination of the personal protective order issued by Judge Yost Johnson on January 23rd, 2024 is appropriate, and the court will vacate that personal protective order in this particular matter. With that, the court states if the parties do have issues concerning exchanges of children and things of that nature, they have a right to petition in the underlying divorce action. The court will set then some different parameters and restrictions, etc., to parenting time, maybe meeting at a police station. The court could order as well that the parties would do exchanges involving third parties so that the party, in this case, the petitioner, would not be present. The court can do that, but I don't believe that, again, entering a personal protective order at this point is the appropriate substitute for other conditions under parenting time. And as a result, the court will vacate that order, and court will sign that. You'll get that in a few days. And again, anything else that you need to proceed with, please do so in the divorce action, unless there would be an appropriate basis under the personal protective order statute, but the court doesn't find that at this time. So that will be the order of the court.
Bridget Rafferty, Terrence Rafferty, two plaintiffs versus Christina Rafferty, attorney Julia Kazuli is filling in for attorney Kelly for plaintiff.
Good afternoon to all of you.
Good afternoon.
Good afternoon.
I'll go to the attorney first, as they represent the plaintiffs. And Ms. Zuli, enlighten me, what's happening in the case?
It is my understanding, Your Honor, that the parties had some sort of an agreement to mediate. There was an issue with paying the fee, and then we found out later by the defendant that she no longer wants to mediate. So upon discussion with Mr. Kelly, he had indicated to me that the parties would like to move forward with scheduling, I believe, an evidentiary hearing on this matter.
Okay. Miss Christine Rafferty, what's your position on this matter?
Good afternoon, Your Honor. I had found out on February 14th, after being contacted by the VA, that in the planning of a memorial service for my late husband to be memorialized in Battle Creek, that Bridget Rafferty had already, without my knowledge, signed paperwork as my husband's next of kin in order to receive his burial flag and military honors at the funeral that she planned. And I am now having to go through the process with the VA and the National Cemetery Service of demonstrating that this was not correct. My children and I are the next of kin. And I take great offense to the fact that Bridget chose to fraudulently sign documents denying the existence of the children.
That's not really involved in our case.
Well, that's why I have changed my mind. I don't believe that people who don't know my children, who defrauded to take something of theirs that their father served his whole life for, should be able to establish a relationship with my children. I no longer agree to it.
Okay. Well, okay, it looks like we've reached impasse and the mediation isn't going to be, again, helpful in this matter. So what we will do is we will contact Miss Kelly at this point and then Miss Christina Rafferty, and we'll set up a time when they're available and we'll have a trial on the matter.
Thank you, Your Honor.
Okay, we'll have it set for trial, and I guess Ms. Zuli, what do you think time-wise we're
If
going to
we
need?
could, yes, I believe if we could get at least 60 days, 40, 60 days, Your Honor, just in case for any trial prep.
Okay, well, they'll set that based upon when they call you, et cetera. How many days do you think we're going to need for trial?
I would say 1 day should suffice.
Okay.
Should.
Miss Christina Rafferty, you think 1 day would do this?
Absolutely, Your Honor.
Okay. Okay, we will contact you and probably the next day or so and set up a time when everyone's available, and then we'll try the case.
All right, thank you so much, Your Honor.
That's good. Thank you, Your
Okay.
Honor.
Okay, thank you.
Bye.
Free to go. Have a good afternoon.
For
You
plaintiff
as well.
and Attorney McNiff for defendant.
Okay. Good afternoon to everyone. Go to you first, Mr. Todd. I've been informed that you did have a resolution at mediation. Is that accurate?
Yep, we have, and we're just finishing circulating the signed agreement. So I
Okay.
think we just want to do a pro-con today.
Okay.
You should have the signed one. We just emailed it.
Yep, I just got it.
Okay. So you acknowledge that we did have resolution, Ms. McNiff?
That's correct, Your Honor.
Okay. Go ahead, Mr. Todd.
Thank you, Your Honor. Ms. Moore, do you remember signing a complaint for divorce?
Yes.
At the time you signed that complaint, were all those allegations true, and do all those allegations remain true today?
Yes.
Did you live in this state for at least 180 days in this county for at least 10 days prior to filing the complaint?
Yes.
Have you had an opportunity to review the proposed judgment and believe it equitably divides all of your assets and debts?
Yes.
Are you currently pregnant?
I am not.
Does the judgment of divorce, are the custody, parenting time, and child support provisions in the judgment of divorce in your children's best interest?
Yes.
Has there been a breakdown of the marriage relationship to the extent that the objects of matrimony have been destroyed and there remains no reasonable likelihood that the marriage can be preserved?
Yes.
Would you briefly describe for the court why that is?
We can no longer trust each other and we can no longer see eye to eye on anything.
Nothing further, Your Honor.
Okay. Court is satisfied that the testimony does establish a statutory basis. There has been a showing there's been a breakdown of the marital relationship. the court will preserve the proofs at this time, pending the running of the time. We have about 12 days before we can get that entered, and hopefully we'll get the front of the court approval at about that time. So just so you know, you're not divorced till I sign that paperwork, which again may take a couple of weeks yet. But I want best of luck to both of you. I hope everything works out for you. And we'll end this proceeding at this time, and you can have a wonderful afternoon.
1:34 p.m.
Thank you.
Good afternoon to both of you. I've been informed by the mediator that you were not able to get the matter resolved at mediation. Is that accurate, Mr. Hanker?
Yes.
Okay. And Ms. Gilman, is that your understanding as well?
Yes.
Okay. So it looks like we're going to need a trial date. What we will do is we will contact both of you and we'll see when you're both available to have a trial in this matter, and then we will do it, probably set it for a one-day trial and address everything we need to at that point. Is there anything else, Mr. Hanker, you have, or any questions?
No, I don't think so, Your Honor.
Okay. Ms. Gilman, any questions you have or anything else before we conclude?
No, Your Honor.
Okay. We will be in touch with you. We'll set up a trial date and then proceed at that time. Okay? Okay. Thank you. You're free to go. Have a good afternoon.
1:36 p.m.
Thank you. You too.
You too, Your
Good
Honor.
afternoon to both of you. I'll go to Ms. Smith first because she is the plaintiff. Ms. Smith, we did get notice that you were not able to get resolution at mediation. Is that correct?
Yes, that's correct.
Okay. And Mr. Daniels, that's your understanding as well?
Yes, sir.
Okay. Well, at this point, then what we're going to have to do is set this for trial. We will set it for a one-day trial. And what we'll do is we will be in touch with both of you, and we'll call you and then probably put you on a conference call and then see what date works for both of you. And then we will set it for trial. Okay?
Okay.
Yes, sir.
Ms. Smith, do you have any questions at this point?
No, sir.
And Mr. Daniel?
Not at the moment, sir.
Okay. Okay, we will be in touch with you probably in the next day and probably sometime tomorrow and set up a trial date. And then we'll proceed.
Roger that.
Okay? Thank you. You're free to go. Have a good day.
Thank you, sir. You too.